Dr. Babasaheb Ambedkar Open University.
Good evening, friends. I am Dr. Dhaval Pandya. Welcomes you all from the Chaitanya Studio of Dr. Babasaheb Ambedkar Open University. As we discussed in last lecture, we are on Indian Contract Act 1872, Part 2. Syllabus is in front of you. In previous lecture, we learned about special contract, and today we are going to learn about special contracts, contracts pledge and contracts of agency. We learned about contracts of agency. Today we are going to learn about essential of relationship of agency. What we covered last time: contract of pledge by non-owner, rights and duties of pawner and pawnee, contract of agency, definition of agent, definition of principal. Now essential of relationship of agency. Okay. There are two essentials of the relationship of agency. First, agreement between the principals and the agent. The agency depends on the agreement but not necessarily on the contract. As between the director and third parties, anyone can become an agent. As such, even a minor or a sick-minded person can be an agent. However, the principal is responsible for the act of said agent. Second, intention of the agent to act for the principal. Whether a person intends to act on behalf of the another is a matter of fact. When a person intends to act on behalf of another, the agency may arise even if the contract between the parties stipulates that there is no such relationship. Rules of agency. There are two important rules of agency. First, what a person can do personally can be done through agent. This rule, of course, is subject to certain known expectation, such as when the act what is performed is of a personal nature, like signing, or is attached to a public office. Second, he who does an act through another can be dealt by himself. This means that the act of an agent subject to certain conditions are act of the principal. Section 226 clearly states that the act and contracts of an agent will have the same legal consequences as if the contract and act performed by the director in person had been creation of agency. A person who has the capacity to contract and contract of himself or for another person, if you adopt the first method, it is not about agency. If you adopt the second method, then there arise the concept of an agency. The person who represents another in their dealing with third party is called an agent, and what person who is represented by an agent is called a principal. Few are different modes of creation of agency. First, agency by express agent, agency by operation of law, agency of ratification, agency by express agreement. The authority of any agent can be expressed or implied. Section 186. Normally, the authority given by the principal to his agent is an express authority which allows the agent to bind the principal for act performed within the scope of his authority. Second, agency by implement agreement. Situation or relations of the parties can be deducted from the circumstances of the case, and the things spoken or written or the ordinary courses of the negotiation can be conducted as circumstances of the case. Section 187. Third, agency for ratification. A person can act on behalf of another person without their knowledge or consent. Now, duties of agent. Duties of agent. An agent owns a number of duties of his principal, which varies in degree according to the nature of agency. These duties are to carry out the work given by the director first. Second, to carry out the work with care, skill and diligence. Third, to communicate with the director in the case of defaulty. Fourth, do not try on your own. Fifth, pay the sums received by the principal. Sixth, to protect and preserve the interests of the principal in the event of his death or insolvency. Seventh, not to use information obtained in the course of agency against the principal. Eighth, not to make secrets profit from agency. Ninth, not to set up an adverse title. That is very much important. 10th, not to put himself in a position where interest and duty conflict. And 11th, and the last one is not to delegate authority. Not to delegate authority. This is the 11th duty of the agent. 10th was not to put himself in a position where interest and duties conflict, and the 11th duty of the agent is not to delegate authority. So these we can see total number of duties are 11. So these are the duties of the agent. Now, liabilities of agent. Few liabilities. Few liabilities are liabilities of agents are: first, actually the agent, like the principal, with their activities, but there are more situation in which the agent finds personal responsibility. The situations are like liabilities regarding damage and misconduct. In case of breach of contract by an agent, he is responsible for paying the damages if he is found guilty of misconduct. The principal may delay his remuneration for the part of the business he has measured. Second, second one is personal liability of the agent when it is established by commercial customs or use. Third, when an agent expressly accepts being responsible. Fourth, liabilities for their unlawful act. And fifth, responsibility for the action of subagents. So these are 5 liabilities. Now, rights of agent. An agent has the few rights, like first, rights of retainer. Second, rights to receive remuneration. Second right is right to receive remuneration. Rights of lien. Third one is right of lien. Fourth one is right of indemnation. Right of indemnification. Right of compensation. Fifth, and right of stopping in transit. So these are 6 rights of agents. First to 6 we can see all the. Now, duties of principal. Okay, duties of principal. First, to indemnify the agent against the consequences of all lawful acts. First. Second, to indemnify the agent against the consequences of act done in good faith. Second. Third, to indemnify agent for injury caused by principal's neglect. And fourth one is duty to compensate, and fifth one is duty to reimburse. So these are 5 duties of principal. Now, rights of principal. To recover damages, to obtain an account of secret profits and recovery them to for remuneration. And the third is to resist against a claim for indemnity against liability in search. So these are the right of principals. Now, termination of agency. Okay. After the termination of the agency, the agent is free of any fiduciary obligation to the principal derives from the relationship of agent. The parties may terminate the agency by mutual agreement, as agency cannot be reclaimed by the act of one of the parties and must be done mutually. Termination of agency by the operation of law. Expiration of time. First. Fulfillment of the object. Second. Third, death or madness of either parties. Fourth, insolvency of the director. Fifth, destruction of matter. Sixth, principal alien enemy, and liquidation of company. These are 7 termination of agency by the operation of law. Now, termination by the act of parties. Termination of the agency by the principal and termination of the agency by the agent. There are two things. So now termination of the agency by both parties of the contract. Third. Now, okay, with this we conclude our unit. So now long question and short question. First, what is contract of pledge? Discuss in detail. Second, right and duties of pawner and pawnee. Third, what is contract of agency? Discuss in detail. Creation of agency, duties, liabilities and right of agency, duties and right of principal, and eighth, termination of agency. Okay, with this we conclude our second numbers chapter. We'll meet again with another unit. Till then, goodbye and take care. Thank you very much.
स्वाध्यायः परमं तप